All right, who's ready?
There's a number in a couple.
Okay. Go ahead and bring up your first client and tell me who it is.
Judge ready on Mr. Loden, Justin Loden.
All right, CR 1923, State versus Justin Edward Lee Loden for plea. Motion to revoke, is that correct?
Yes, Judge. This is state's filed a motion to withdraw and extend. He's going to be adding special needs safety as a condition of probation. We feel like the dual diagnosis program is going to assist him with his issues that caused problems while he was on probation. Hopefully give him a better chance of being successful when he gets out.
All right, and has this plea been run by the probation department? They in agreement or not?
Yes, Your Honor, and I believe that they added a year as a condition so that he had time to successfully complete the special needs safety.
Okay. All right, Mr. Loden, if you'll raise your right hand, sir, I'm going to place you under oath. Sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth? So help you God.
Sir.
Thank you. You can lower your hand. All right. So, Mr. Loden, you're represented today by Mr. Jonathan Manning. Are you pleased with his representation of you?
Sir.
Do you feel like you've had enough time to talk with him about your case and have all of your legal questions answered?
Sir.
Is there anything about the paperwork and the resolution of this case today that you do not understand or don't agree with?
Sir.
Okay, and you heard Mr. Manning indicate to me that you are on a motion to revoke right now, and that the state's agreement with you is that they would withdraw that motion to revoke. They would extend you, and they would amend your conditions of community supervision to require additional things. One of those things being confinement period in the rehab center known as SafeP, and then an extension of your time so that you can comply with all of the other things that go along with that. Is that your understanding? And that's what you're asking the court to approve? And has anyone threatened, forced, or pressured you to make this agreement today? And if I send you down to SafeP, are you going to go down there with a positive attitude and look to learn what you can so that you can battle your substance abuse?
Yes, sir.
Okay, because what I don't want to do is I don't want to put someone down there who's really not interested in getting help.
Yes, sir.
And so you're telling me that you are interested in getting help and you will work diligently to better yourself.
Sure.
Okay, Mr. Manning, anything further?
I think Mr. Loden.
All right, anything further from state? Oh, okay. All right, then the court will grant the state's motion to withdraw. The court will amend the community supervision conditions of Justin Loden to include substance abuse felony punishment facility special needs and the other agreements with regards to extension and those regarding fees associated with the extension of time. Anything else that's between the parties that the court will approve that and amend the conditions to reflect this. All right, Mr. Loden, a lot of people say, hey, good luck to you. I consistently say it's not about luck, right? It's in your situation, it's about effort, it's about attitude, it's about discipline. So I expect you to go down there, work hard, and come out a better man.
Yes, sir.
All right. Thank you, sir. Who's next, Mr. Manning?
Next, I'm ready on Mr. Bird, Zachary Bird.
Zachary Dane Bird, CR 2148 and CR 21108. We're set for plea today. Is that right, Mr. Manning?
Yes, Judge. Mr. Bird was bench warranted to us from TDC.
All right. And I don't think that I have plea papers on Mr. Bird. Can you outline the plea for me?
Yes, Judge. Upon plea of guilty, states agreed to assess punishment at 12 years TDCJ institutional division with a fine of $1,000, $180 restitution, and they agreed to take under section 1245 DA number 2020-0405, which is a possession of dangerous drug, DA 2020-0406, which is a possession of PG3 less than 28 grams, DA 2021-0121, which is DWLI with previous conviction, DA 2021-0122, which is possession of marijuana, DA 2021-0123, which is possession less than a gram, and CR -00180, possession of controlled substance, penalty group 1, less 1 gram, greater than 1 gram, but less than 4 grams.
Did you say CR 21-108 or 180?
108.
108. Okay. All right. I've got that.
It appears that he has 268 days total. That was what Ms. Abney was able to confirm. Upon speaking to my client, he thinks that there may have been some additional time that was unable to be confirmed by the DA's office. And I explained to him the confirmation process of his back time at TDC. But that was all that Ms. Abney was able to confirm based on the warrants.
Okay. What about 290 court cost? Any reimbursement?
$120 reimbursement.
All right. And any forfeiture, weapon forfeitures, or property forfeitures associated with any of these?
No, Judge.
Okay. All right, Mr. Byrd, if you'll raise your right hand, sir, I'm going to place you under oath. Sir, do you swear that the testimony that you give the court today will be the truth, the whole truth, and nothing but the truth? So help you God.
Yes, sir.
All right, you can lower your hand. Your name is Zachary Dane Byrd. Is that correct? Say again.
Yes, sir.
Okay, and just make sure you speak up loudly for me so I can hear you and so my court reporter can take it down. Mr. Byrd, are you a United States citizen who reads, writes, and speaks English?
Yes, sir.
And have you ever been diagnosed with a mental condition?
No, sir.
And you're represented by your attorney, Mr. Jonathan Manning. Are you pleased with him as your attorney?
Yes, sir.
Do you feel like you've had enough time to talk with him about all of these cases and that you've had all of your legal questions answered?
Yes, sir.
Is there anything about any of that paperwork that you've read over with Mr. Manning and that you've signed that you do not understand?
No, sir.
And your signature, where it appears in there, it's a true and correct signature, and you only signed it once you understood what you were signing. Is that correct?
Yes, sir.
All right. And you also heard Mr. Manning read the plea agreement to the court, and that's your understanding of the plea agreement and what you're asking the court to approve today. Is that right?
Yes, sir.
All right, Mr. Byrd, you are charged by indictment with a first-degree felony offense of manufacture, delivery of a controlled substance of penalty group 1, greater than or equal to 4 grams, less than 200 grams. Mr. Manning, I didn't ask you, is that the charge that your client will be pleading to today, or has it been reduced?
That is the charge that he's pleading to today, Judge.
All right, thank you. So, Mr. Byrd, the range of punishment for that charge is not less than 5 years in prison, and it can't be more than 99 years or life in prison. And I see here, and also a fine not to exceed $10,000. And I see here that the plea agreement you've reached with the state legally fits within that range of punishment. So, Mr. Byrd, I would ask you at this time, how do you plead to manufacture or delivery of a controlled substance in penalty group 1 greater than or equal to 4 grams, less than 200 grams?
Guilty, sir.
And Mr. Byrd, are you pleading guilty to that crime because you are guilty of committing that crime and for no other reason?
Yes, sir.
All right, the court does accept the defendant's plea of guilt. Mr. Manning, any objection to the evidence supporting the plea?
No objection to States 1.
All right, States 1 is admitted and the court takes judicial notice of the defendant's judicial confession. Anything further from the state?
Yes, Your Honor. I just wanted to note for the record that the indictment contains 2 enhancement paragraphs. So while we didn't reduce the charge, the state is abandoning both of those enhancement paragraphs to make the plea agreement fit within the proper range. And I believe that the judgment reflects that.
Okay. And Mr. Manning, if you will, since you have the state's evidence, if you would do the court a favor and just mark out the enhancement paragraphs, and the court will, when that comes back to me, I'll make sure that I initial that so that there's no confusion at TDC.
Yes, Judge. I've marked through both enhancement paragraph 1 and enhancement paragraph 2 on States 1, CR 2148.
All right, thank you, sir. All right, anything further from the defense?
Nothing from the defense, Judge.
All right, and Ms. Heiser, can you give me the plea or the evidence to support the plea?
Yes, Your Honor. On March the 1st of 2020, the defendant is driving a vehicle that has no front license plate. He is pulled over and basically admits that he was maneuvering to avoid the police. The officer asked him if he smokes marijuana, and the officer says that he smells burned marijuana. The defendant says he does smoke marijuana, so the officer asks for consent to search the vehicle. The defendant denies consent to search, but tells him basically you can run the drug dog if you have one. So they call Officer Long to run the canine, who does make an alert on the vehicle. They search the vehicle and find drugs, baggies of drugs in several locations throughout the vehicle. The lab tested one of those baggies, which came back at 9.66 grams of methamphetamine.
Thank you, Ms. Heisel. Any objections, Mr. Manning?
No objection, Judge.
All right, then based on the evidence presented to the court finds that there is enough evidence to convict Mr. Byrd of this offense. Court will follow the plea agreement reached between the state and the defense. Court convicts Zachary Dane Byrd of manufacture or delivery of a controlled substance in penalty group 1, greater than or equal to 4 grams, but less than 200 grams, a first-degree felony. The court assesses his punishment at 12 years confinement in the Texas Department of Criminal Justice, orders him to pay a $1,000 fine, $290 court cost, $120 reimbursement fees, $180 restitution, and the court will dismiss under section 1245 DA 2020-405, DA 2020-406, DA 2021-121, DA 2021-0122, DA 2021-0123, and CR 21-00108 under section 1245 of the Texas Penal Code. And the court awards Mr. Byrd 268 days credit towards his sentence for the time that he has spent in jail on this cause. Mr. Byrd, you hereby remanded to the custody of the Van Zandt County Sheriff so he can carry out the terms and conditions of the sentence. Once you are released from custody, Mr. Byrd, you'll be responsible for the court costs and fines that you've received today. It'll be very important that once you're released that you contact the courthouse, meet with a court compliance officer, and make arrangements to work out a payment plan on how to discharge those. If you don't, then a warrant will be issued for your arrest and you'll go through this similar process again, okay?
Yes, sir.
All right, good luck to you, sir. Who do you like next, Mr. Manning?
Judge, I believe we're ready to proceed on arraignment for Mr. Hicks.
Braylon DeMonte Hicks, CR 22356, CR 22399. And do you have the indictments there, Mr. Manning?
Judge, I don't see that made it into my file. It may have fallen out my bag, but if we could just pull up the indictment for the murder.
Yes, sir, will do. Stand by.
My client let me know he has reviewed it, but I would like to do it on record.
Just for the murder charge, not for the evading charge.
Right, we've already waived arraignment on the evading.
Right.
No, he does.
Is that sufficient, Mr. Manning?
Yes, Judge. Still spelled correctly. Your Honor, my client's name is spelled correctly. He understands the charge against him as well as the range of punishment. He pleads not guilty at this time and requests both these cases be set for pre-trial.
All right, the court will enter Mr. Hicks' plea of not guilty into the record for CR 22399. Court will set each case for pretrial hearing. Do you need more time than 30 days, Mr. Manning?
Yes, Judge, if I may. I've reviewed a bulk of the discovery through the evading case, but my understanding is there a significant amount associated with the murder case, particularly media that will need to be reviewed before we can proceed.
What about March 9th?
Judge, I believe that will work. Let me double check. That will work, Judge.
All right, court sets each case for pretrial hearing on March 9th at 1:30. If Mr. Hicks remains in custody, if he's out of custody, it'll be at 9 a.m.
Yes, Judge. Sorry.
Who you like next, Mr. Meany?
Well, Judge, it looks like all the ones that I have in here currently. I do have an update on Mr. McInturf. He called me right before I came to court and said that his ride fell through. I explained to him the consequences of that. He said that he will be here before 5 o'clock. I said, well, the court may not be able to take your plea at that time. And so I told him that if he does show up after I've left, that he can just go ahead and turn himself in under the warrant that will be issued and wait until next week for us to do the plea.
You said that's McInturf?
Yes. Sorry, that's McKibben.
McKibben, okay. All right. Yeah, I think there is a McInturf, but I think he's already in custody. All right, so Travis McKibben has not.
And he said he will be, if he's unable to get a ride here, he will be walking here. And I explained to him that was of utmost importance that he get here one way or the other.
Okay, we'll see if he appears. We have any other counsel that's ready?
Yes, Your Honor.
Good afternoon, Mr. Stevens.
I'm good, Judge. How are you, sir?
I'm doing great.
Nicole Pentler, Your Honor.
Yes, let me see. All right, this is cause number CR 22-283 and 284, State versus Nicole Lynn Pentler. Sure that we're set for docket call today, Mr. Stevens. Go ahead.
That is correct, but we do have a plea workout, Your Honor.
Okay, oh, that's right. Let me think. I think I might have it here. All right. Ms. Pentler, if you'll raise your right hand, I'm going to place you under oath. Ms. Pentler, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, I do.
All right, thank you. Thank you. You can lower your hand. Make sure you speak up loudly and clearly for me so I can hear you and so my court reporter can take down what you have to say. All right, Ms. Pentler, are you a United States citizen who reads, writes, and speaks English?
Yes.
Have you ever been diagnosed with a mental condition?
No.
In this case, you're represented by your attorney, Mr. Bill Stevens. Are you pleased with his representation of you?
Yes.
You feel like you've had enough time to talk with him about your cases and that you've had all of your legal questions answered?
Yes.
Is there anything about the paperwork that you've read and signed today that you do not understand?
No.
And Mr. Stevens, do you believe Ms. Pentler to be competent today?
Yes, sir, I do.
And you've explained to her her rights as they pertain to this case and also the way that community supervision works?
Yes, I have, Your Honor. I think she does understand.
All right.
Yes.
Ms. Pentler, you are charged by indictment with a second-degree felony offense of burglary of a habitation. Burglary of a habitation carries a range of punishment of not less than 2 years in prison and not more than 20 years in prison, and an optional fine not to exceed $10,000. I see here that the plea agreement in your case is that you would plead guilty to that crime. The state would be recommending that your punishment be assessed today at 8 years confinement, which would legally fall within the range of punishment. And the state's recommending to the court that the court suspend that sentence of 8 years and place you on community supervision for a period of 6 years. As part of the plea agreement, you would also pay a $2,500 fine, $290 in court costs, reimbursement fees of $1,295. And the state would be dismissing some cases in order to resolve your business here in Van Zandt County. Is that your understanding of the plea?
Yes, sir.
And that's what you want the court to approve today?
Yes, sir.
and you've gone over your conditions of community supervision and you understand what's required of you.
Yes.
Okay. All right, Ms. Pentler, to the charge of burglary of a habitation, how do you plead?
Guilty.
Are you pleading guilty to that crime because you are guilty of committing that crime and for no other reason?
Yes.
Has anyone threatened, forced, or pressured you to plead guilty?
No.
All right, the court does accept the defendant's plea of guilt. Mr. Stevens, any objection to the evidence supporting the plea?
No, Your Honor.
All right, states one is admitted and the court takes judicial notice of the defendant's judicial confession. Anything further from the state?
Yes, Your Honor, in both the cause that is being pled to and the indicted cause that is being taken into consideration, we are in victim compliance. However, we have nothing to present to the court at this time on that front.
All right, thank you, Ms. Heisel. Anything further from the defense?
No, Your Honor.
All right, of course, going to review the evidence briefly. All right, of course, reviewed the evidence and finds that the evidence does support the plea and that there is sufficient evidence to convict Ms. Pentler of this offense. The court will follow the plea agreement reached between the defense and the state. Court hereby convicts Nicole Lynn Pentler of the second-degree felony offense of burglary of a habitation. Court assesses her sentence today at 8 years confinement in the Texas Department of Criminal Justice. Court suspends that sentence, places her on 6 years community supervision, orders her to pay a $2,500 fine, $290 court cost, reimbursement fees, $1,295, and the court dismisses under section 1245 DA 2022-346, a theft of property, DA 2022-988, burglary of a habitation, DA 2022-987, burglary of a habitation, DA 2022-989, burglary of a habitation, DA 2022-914, possession of controlled substance, DA 2022-916, burglary of a habitation, DA 2022-915, possession of marijuana less than 2, and CR 22-284, burglary of a habitation. Ms. Pentler, you're hereby remanded to the custody of the Van Zandt County Community Supervision and Corrections Department so they can carry out the terms and conditions of the sentence. You'll step over with a deputy to be fingerprinted. After that time, you'll speak with the probation officers and they'll give you more information about the next steps.
Okay, thank you, Your Honor.
You're welcome.
One more. Judge, I think we had Mr. Aguardo on the docket today. However, he's at Terrell State Hospital.
He is in Terrell. So what we'll do is we'll just let's set him out about 90 days or so. And then
Okay.
that way we can do an update, see if we have any update from Terrell State. I'm just going to look down in April. Do you have your calendar available for April?
I'm in April's good, Judge.
You want to do it on April Fool's Day?
Sure, why not? Might as well.
I'm not going to be here that day. Let's do April 4th
All right, sir.
for a status, just so we can see how he's doing.
All right, sir. Do it at 1:30, Judge?
Yes, sir. Yeah, that'd be at 1:30. And if for some reason, as we get closer, if you do not have anything else on the docket that day, then just let us know and you can zoom in from your office. I don't want you to make a trip over if he's not here and we're not dealing with any issues, if it's just a status.
All right, thank you, Judge.
All right, is that all you have, Mr. Stevens?
It is, Judge.
All right, thank you. Good to see you.
Good to see you, Judge.
Ms. Thompson, you ready?
I am, Your Honor.
All right, court calls number CR 22208, State versus Tiffany Nicole Cooey. Ms. Cooey, if you'll raise your right hand, I'm gonna place you under oath. Ms. Cooey, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
All right, thank you. You can lower your hand. All right, Ms. Cooey, are you a United States citizen who reads, writes, and speaks English?
Yes, sir.
Have you ever been diagnosed with a mental condition?
No, sir.
In this case, you're represented by your attorney, Ms. Ann Thompson. Are you pleased with her as your attorney?
Yes, sir.
You feel like you've had enough time to talk with her about your case and have all of your legal questions answered?
Yes, sir.
Is there anything about the paperwork that you've read over and signed today that you do not understand?
No, sir.
And where you've placed your signature, that is your true and correct signature, and you only signed once you understood what you were signing. Is that right?
Yes, sir.
All right. And Ms. Thompson, do you believe Ms. Cooey to be competent today?
I do, Your Honor.
And you've explained to her her rights as they pertain to this case?
She does, yes, Your Honor, I have.
And the waiver that she's making today of certain rights, you believe she's doing so intentionally, knowingly, and voluntarily?
She is, Your Honor.
All right, Ms. Cooey, I see that you are charged by information. So was Ms. Cooey ever charged by indictment, or it's always been by information?
Your Honor.
By indictment?
It's an indictment, Your Honor.
All right, our judgment says information, so we can make a correction and get that fixed. All right, so Ms. Cooey, you are charged by indictment with a state jail felony offense of possession of a controlled substance in penalty group 1 less than 1 gram. That does carry a range of punishment of not less than 6 months in prison and not more than 2 years in prison, and a fine, optional fine that cannot exceed $10,000. I see the range of not the range of punishment. I see that the plea agreement in your case is that you would plead guilty to that charge in exchange for the state's recommendation that your sentence be assessed at 12 months confinement in state jail with a 0 fine, court cost of $290, restitution of $180, reimbursement of $40, and you would receive 33 days credit towards your sentence for the time that you've been in jail on this cause. Is that your understanding of the plea agreement?
Yes, sir.
All right, that's what you're asking the court to approve today.
Yes, sir.
All right, Ms. Cooey, how do you plead to the state jail felony offense of possession of controlled substance in penalty group 1 less than 1 gram?
Guilty.
Are you pleading guilty to that crime because you are guilty of committing that crime and for no other reason?
Yes, sir.
Has anyone threatened, forced, or pressured you to plead guilty to this crime?
No, sir.
All right, the court does accept the defendant's plea of guilt. Ms. Thompson, any objection to the evidence supporting the plea?
No objection, Your Honor. Let's have a special argument in a minute.
Okay, all right, then the court admits State's Exhibit 1 and the court takes judicial notice of Ms. Cooey's judicial confession. Anything further from the state?
Yes, Judge, just for the record, Ms. Cooey was originally indicted with an enhancement paragraph that enhanced the state jail punishment range to a 3rd-degree punishment range. She had 2 prior state jail convictions. The state is abandoning the enhancement to leave this as a state jail, which she has been admonished as to. I just want to make sure the record's clear that we are abandoning the enhancement paragraph in the indictment. I'm not sure that the judgment reflects that, but we will get that corrected along with the fact that she was indicted and not by information.
Okay. Yeah, perhaps,
We'll add, I'll make sure it says abandoned and abandoned in the
Perfect.
judgment.
thank you. I think it'll assist TDC, State Jail Division. All right, anything else from the state?
Nothing further, Your Honor. We'd rest and close at this time.
Thank you, Mr. Woodwhite. Ms. Thompson, proceed.
Your Honor, just a request. I just learned a few seconds ago that Ms. Cooey advised that her oldest daughter tried to commit suicide last night, and she's asking the court to allow her a week before, and allow herself to turn herself in. So the try to assist getting your daughter into a hospital, whatever needs to be done.
Who's going to be caring for your daughter when you're away?
Well, my grandmother is right now, but I'm trying to get her into my father's care, who's more mentally stable than my mother's family.
And do you think this act was in response to you going into custody today?
Partly, but she sees a therapist every week, so Yeah, I believe it is.
My policy is that I don't allow pleas of guilty and then resetting when it's for time. I've had individuals who were actually still wanted, and that's been since 2019. So unfortunately, Ms. Cooey, I'm sorry for your circumstances, but I'm gonna deny your request to delay your incarceration.
Yes, sir.
All right, court's going to review the evidence. All right, court's reviewed the evidence. I do find sufficient evidence to convict the defendant of this offense. The court will follow the plea agreement reached between the state and the defense. Court hereby convicts Tiffany Nicole Cooey of possession of a controlled substance of penalty group 1 less than 1 gram. State jail felony. The court assesses her punishment at 12 months confinement in state jail TDC. Orders her to pay court costs of $290, restitution of $180, $40 reimbursement fees. Court awards Ms. Cooey 33 days credit towards her sentence for the time that she has spent in jail on this cause, and the court does acknowledge that the state has abandoned the enhancement paragraphs in both paragraph 1 and 2 as contained in the indictment. Ms. Cooey, you're hereby remanded to the custody of the sheriff so he can carry out the terms and conditions of the sentence. I hope everything's okay with your daughter, and I'm sure if you talk to the jail, they'll make sure that you understand how to have contact with your family so you can assist her in getting her the help that she needs.
Yes, sir.
All right. All right, you'll step over to Deputy Everett. He's going to take your fingerprint.
That's all I have, Your Honor. May I have excused?
Yes, thank you, Ms. Thompson. Good to see you. Tuesday, okay. Yeah, let me talk to her about that and see what the state says. Mr. Schmidt, are you ready?
So
Who are you ready on, sir?
on Mota and Dixon.
All right, let's go. Alejandro Mota, CR 22113. Go ahead, Mr. Schmidt.
Judge, we've reached an agreement with the state to withdraw the motion to adjudicate and continue with some amendments. Ms. Mota was pled not too long ago, and she was supposed to go to safety. She had a medical emergency and they released her from the hospital, and instead of bringing her back. That's what triggered the MTA and some other issues. Plus, the court recalls that her bond was revoked in court for substance issues. So the amendments basically are going to put her back at square one with what the original conditions were. She will be required to submit to safety. She will have an additional 6 months of probation, a term that would expire April 12th, 2027. In addition to that, she's going to serve 80 days in the county jail with credit for that time over various dates.
Okay. Yeah, the court is familiar with Ms. Mota's procedural history. I do recall Ms. Mota was going to go down to safety, had that medical emergency, and we did release her. And then I think we amended to just put her on intensive supervision straight without safety. And then I believe Ms. Mota had some substance abuse issues that brought her back on this amended motion to adjudicate. So I think originally this was always the court's plan for Miss Mota. We just had that intervening cause of the medical emergency that put Miss Mota back out on the street without the help that she needs. So, Miss Mota, this might be the only time that I can recall seeing you when I think you're sober. All the other times that you've appeared in court, it was obvious to everyone around you that you were under the influence of some drug or narcotic. And the fact that you're standing still today, that you're alert, that you're attentive, tells me that you need rehab, you need safety. Okay. And so I'm going to approve the agreement that you reached today, because that was our original plan for you. Our plan was not to send you to prison. It's not to take you out of society. It's to try to get you the help that you need so that you can fight your substance abuse. Okay. So I don't know what your attitude is right now. I hope that it's one that you're willing to go down there and work hard at learning what it is that they can teach you, keeping an open mind, trying to make yourself better so that when you come back, you won't be in a revolving door of going in and out of prison due to drug use and drug abuse. Are we on the same page?
Yes, Your Honor.
Okay. All right, Ms. Mota, do me a favor, raise your right hand. I'm just going to place you under oath real quick. Ms. Mota, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, Your Honor.
All right, you can lower your hand. All right, Ms. Mota, I've heard what Mr. Schmidt has said your agreement with the state is. I do think that that is in your best interest. That's what you're asking the court to approve today. Is that correct?
Yes, Your Honor.
And Ms. Mota, has anyone threatened you, forced you, pressured you, told you that you had to enter into this agreement today?
No. No.
And Mr. Schmidt, do you believe that Ms. Mota is competent today and that she understands the waivers that she's making, and that she understands that she's amending her community supervision, extending it, and that she's doing all of that intentionally, knowingly, and voluntarily?
I do, Judge.
Okay. All right. The court will approve the agreement. The court grants the state's motion to withdraw. The court will continue and extend Ms. Mota on community supervision for an additional 6 months to extend on April 12th, 2027. The court will order as conditions of community supervision that she successfully attend and complete the substance abuse felony punishment facility, and that she serve 80 days in jail as a condition of community supervision. Does she have credit for those 80 days already, Mr. Schmidt?
Yes, Judge.
Okay, so the court will award her 80 days credit for time that she has already spent in jail. So Ms. Mota, I hope I get a good report on you after you go to SafeP and that you come out. The probation officers will be getting progress reports, based on your conduct, your behavior, how you act, all those things. And if you don't go down there and do what you're supposed to do, given this opportunity, Mr. Schmidt has gotten you this opportunity to kind of get you back, as he said, to square one. Probably some other DA's offices and other courts may not give you that opportunity, but we've done that here today. So I hope you take advantage of it and you appreciate it for what it is. If you don't do what you're supposed to do, that's going to be relayed back to me. And if we have another hearing like this, it's not going to be as polite. You understand?
Yes, Your Honor. I do.
All right. All right, Ms. Mota, step over. I don't think there's anything for you to sign. I think she's already signed her extension and everything. Is that correct, Mr. Schmidt?
Yeah, the paperwork is complete on her end.
Okay.
I'll give that.
Okay. All right, Ms. Mota. So now it's about attitude, effort, discipline, working hard. Okay. So go do what you got to do to come out a better person. All right.
Okay. Thank you,
All
Your
right.
Honor.
You're welcome. Who's next, Mr. Schmidt?
David Dixon.
David Paul Dixon, CR 22-269. Is this a plea today, Mr. Schmidt?
Is Judge, we're going to be entering a plea on both cases, a burglary of a building and a misdemeanor assault. They're to run concurrently on the CR 22-269. The terms are that Upon a plea guilty, the finding of guilt be deferred, be placed on 2 years community supervision, assessed $1,000 fine, $290 in court costs, and $535 reimbursement. In addition, the terms are substantially the same on the misdemeanor assault, deferred 2 years, 0 fine, $270 in court cost, and a $30 reimbursement fee. In addition, and Mr. Woodwike, our plan today is to resolve all of his outstanding business. I do know that I had received a rejection notice from a no bill from the DA's office some time ago on a possession case. But there is no 1245 language in the judgments. So it would be my understanding that he might have something that should have been included as a 1245 in this agreement. And it might be a secondary burglary of the building, but I'm not certain. And I want to clear that.
I think there is, I believe it's a duplicate charge burglary of a building. He is being held on. I will make sure that disposition is sent. We will flat reject it at this time.
Great, thank you.
In conjunction with the plea, obviously, but.
All right.
And Mr. Schmidt, is it Class A assault family violence or just Class A assault?
Class A assault for the judgment.
Okay. All right, so no restitution or forfeiture of any property or weapons, correct?
No, sir.
Okay, all right, and can you tell me, Mr. Schmidt, what is the cause number for the misdemeanor offense? And is that in my court pending right now?
It's got the county court of law in the heading. It's 2022-382.
2022-00382. Do we know if that was transferred up? Probably not.
Honestly, Judge, I can't recall. It is possible that I intended to file a motion to transfer, but with the back and forth filings, I can't recall if I ever did.
All right, give me just one moment, let me check. Yeah, that appears to still be in Judge Winter's court, so. It looks like that's set on January 25th. How do y'all want to proceed on the misdemeanor?
Excuse me, sir?
I said, how do y'all want to proceed on the misdemeanor? It's
I'd like to resolve it. I'd file an oral motion to transfer to the 294th District Court and ask this court to proceed on the oral motion without the input of the county court of law judge. That's what I want.
Yeah, I'm not sure the statutes allow me to do that. Because I don't believe my statute says that I have concurrent jurisdiction with the county court of law. Yes, I have a concurrent jurisdiction with the county court. And transfers in and out of court require approval of both judges. I don't doubt Judge Winters would object. I'll tell you what I may do. I may just consider it today and then I don't know.
I guess at the end of the day,
Were you appointed on this one, the misdemeanor assault?
yes, sir.
Yeah.
Yeah, it's all one standard appointment.
I mean, but I both understand the concern I have, right?
Yes, sir. I understand the concern. I didn't realize that it hadn't been done, but ultimately, from our perspective, I believe that. I believe that the main, obviously, we set these today. They're both probation deals. Mr. Dixon's anxious to get out of custody and start taking care of his business. I'm not certain if the misdemeanor is holding him in jail, but I would assume that it is, just for the sake of argument. And whatever we could do to expedite a resolution and get him out of custody, we'll do. And I can't think of the best way to do it. I could file a motion, but by the time I got this reviewed and approved, we'd be down the road anyway.
All right, I'll tell you what, Mr. Dixon, just have a seat and I'll recall you back up here in just a moment. Let's move on and then if I get a break, I'll run and talk to Judge Winters if I can, if he's in. And we'll see if we can't come up with something real quick.
Cool, thanks, Judge.
Mr. Manning, just 1 second, okay? All right, Mr. Manning.
Yes, Judge, we're ready to reset my last three.
All right, is this Ms. McGahee?
Yes, Judge, it is.
All right, I thought so. All right, this is CR 2183, State versus Tracy Renee McGee, and this is motion to revoke.
Yes, Judge, the state's provided their standard offer of the number that was given at the plea. Obviously, my client has a hard time swallowing that at this time. So we request to be set on the contested docket, and I'll continue working this case with the prosecutor.
Okay. All right, can we set it January 26th, Mr. Manning?
Judge, I think that'd be fine.
All right, court sets Ms. McGahee for contested hearing on January 26th at 1:30.
Judge, I don't know if, not to interrupt, I don't know if Mr. Schmidt can hear. My office is confirming that Mr. Dixon is not being held currently on the misdemeanor. So we may be able to resolve this without having to find Judge Winters at the current hour, and then he can come back on his next court date, which I believe is in 2 weeks.
He
Well,
said he could hear.
Well, let's put a pin in that because I believe that Ms. Tabraham's going to get an order to transfer in front of Judge Winters here in a moment. So I think we're going to be able to accomplish what we need today.
That works as well.
So we'll make that a plan B, Mr. Woodwhack, and I do appreciate that.
Thank you, Your Honor.
Judge, also ready on Mr. Villarreal.
Sergio Villarreal, CR 21373.
Judge, this was also transferred from TDC. Unfortunately, because of the lateness of him getting transferred here, I was unable to speak to him about the state's offer prior to today, but he is going to accept it. Request that he be set on Tuesday's docket to go ahead and get his resolved on this case.
Tuesday next week, January 10th.
Yes, Judge.
All right, court will set Mr. Villarreal for plea on January 10th at 1:30.
And finally, Judge, I believe the last one I have is Mr. Lyons.
Takithian Lyons. CR 22-152 and 276. Mr. Lyons is set for docket call, I believe, final docket call.
Yes, Judge. Mr. Lyons has chosen to take the state's best offer, which is going to be time on a unfiled case. We request to be reset so the state can file a case and we can proceed under that agreed plea.
Okay. Tuesday of next week.
That's up to the state judge.
I can get it filed if that would be convenient for the court and Mr. Manning.
Okay. We'll set Mr. Lyons to enter his plea before the court on January 10th at 1:30.
And Judge, with the exception of Mr. McGivens, I believe that concludes my business. May I be excused.
Yes, and so what I'll do on Mr. McKibben, I'll go ahead and ask Deputy Everett to have his name called there. I'll ask Deputy Woosley to call his name here. If not, then we'll go ahead and get a judgment NISI available. That way, if he appears later, we can go ahead and take him into custody.
Yes, Judge.
Deputy Everett, can you have the jail go ahead, the lobby of the jail called for Travis McKibben, and I will pass that. Well, could you also text Deputy Woosley and ask him to do the same here and then let me know?
Yes, sir.
Thank you, sir. I appreciate it. All right. Carl Long. Back here. All right, this is writ number WR 22111. And is this a writ seeking bail reduction only, Mr. Harden?
Yes, Your Honor, that's all we have before the court today.
Okay.
I have to visit with the state, but the state's had a copy of this for about 15 to 20 days. So I do not know what the blood pressure of the state is on this, but we had asked the court to reduce the bonds to a manageable number, so my client would have an opportunity to obtain his release. We're asking the court to reduce it from approximately 400,000 down to 26,000. He has pending a reckless driving, evading arrest, detention with motor vehicle, and evading arrest, detention on foot, and unauthorized use of a motor vehicle, and a prohibited weapon, carrying an unlicensed weapon with a previous felony conviction, and manufacturing delivery of controlled substance. There's also a criminal mischief charge of injuring or damaging a game animal fence. And those charges, except for the possession case, arise out of a stop on the 9th of November. The two additional charges arise out of a search, I understand, that occurred while my client was in custody on the 15th of November. And he obviously does not have the funds to pay that kind of a bond. And if the state is agreeable to reduce to the number that I'm asking, he'll have a total bond of $26,000, which he may be able to make, but we can't have any guarantee that he'll be able to do that. If the court will inquire of the state what their blood pressure is, I can put on whatever evidence the court needs to support this motion.
All right, Mr. Long, if you'll raise your right hand, I'm going to place you under oath. Sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth? So help you God.
I do, Your Honor.
All right, and Mr. Harden, you call your client for the limited purposes of a bail reduction.
Yes, Your Honor, I do. State your name for the record, please.
Carl Edward Long,
Mr. Long, what is your home address?
627 Van Zant County Road, 3847,
And
Willis
how,
Point, Texas.
and how long have you lived there?
I approximately lived there for about 2 years now.
And you have a prior criminal history, do you not?
Yes, sir.
And you're not trying to hide that from the court, are you?
No, sir.
I'm sure that's available through the state, through the court. Have you had any previous instances where you were on bond and you failed to live up to the bond conditions?
No, sir, I completed every one of them.
Uh, Would you tell the court what you have in the way of assets that would give you the ability to pay a bond of $26,000, but not almost $400,000?
I do have one of my old jobs back that I make $1,000 a week. And I have a truck that I can definitely sell to make the money. I mean, I'm just trying not to lose my last vehicle. I've kind of lost everything now that this has happened. I've sold everything I've had except for my truck. I was gonna use it to get back and forth to work if I can make the bill.
Okay. Do you have the ability to borrow any money from anyone in your family or anyone that you know that would assist you in paying this bond that is currently set?
Not at this time. I
Uh,
have friends and family, you know, they help me with my commissary. That's about it right now.
What are your average monthly living expenses currently? If you were allowed to be returned home?
They are anywhere from, I would say, 1,000 to 1,500.
Okay, so with an income stream of approximately $4,200 a month, you would have 1,000 out of that, leave you 3,000 a month. Okay.
I do plan on moving to a different place, back to where I was. I know it's a place that I shouldn't be at. Everybody's never made it, so I wanted to move probably to my brother's right here in Coffee.
Okay. Pass the witness.
State, any questions of the defendant?
No questions, Your Honor.
All right, anything further, Mr. Horton?
Nothing further from this, other than I'd ask the court to consider that there's no way in heaven's name that this man can make a bond on $400,000. He's been incarcerated since November the 9th. And although $26,000 is a far cry from the 400 it's currently set at, I think it's reasonable in light of the circumstances and the fact that he's not able to assist me in preparation for the defense of his case. This is a case that is yet, any of these cases have yet to be filed. So he's been incarcerated continuously since the 9th of November.
Thank you, Mr. Horton. Anything further from the state?
Yes, Your Honor, brief argument. State shows that Mr. Long has been in for 58 days, and the state does have the cases in our office. They're waiting for assignment. So we do anticipate that we will be able to indict Mr. Long before the 90-day mark. Additionally, the reason that his bonds are accumulated, or one of the reasons that his bonds accumulate to such a high amount, is because he has 8 separate charges on very close date, including evading arrest with a vehicle, felon in possession of a firearm. So state obviously has great concerns about Mr. Long's willingness or ability to reappear for court in the event that the court were to lower his bonds at this time. We do believe that we will be able to get him indicted before the 90-day mark.
Any response, Mr. Horton?
Well, Judge, as the court knows, bond should not be used as an instrument of repression to keep someone in jail beyond their ability to make pay, secure their release so that they can defend themselves in this case. I don't believe that almost $400,000 in bonds is appropriate under the circumstances. And the state's got to make out its case before it can secure any conviction. So I would ask the court to consider this in light of his ability to pay, the fact that he has no assets, has no ability to pay other than earnings that he could achieve if the court released it.
Okay. All right. The court will take the evidence and the arguments under advisement, and I'll issue a ruling at the conclusion of the docket today.
I would be excused.
Yes, sir. And I'll make sure that you get, both you and the state get a copy of the court order.
Yes, Your Honor. May I be excused?
Yes, thank you, Mr. Harden. Good to see you. Mr. Ashmore, I'm sorry you're not feeling well, sir.
Thanks, Judge.
Appreciate you being here. Well, let's get you in, let's get you out.
Well, Jamie. Judge, here on Mr. Hart's case,
All right, this is cause number CR 22-146, State versus Jamie Floyd Hart. Mr. Ashmore, understand this is a plea, is that correct?
Yes, Judge.
Okay, and I see the plea here, and I understand that you got strep throat today, and I'm sure that's probably pretty painful, correct? So
Yeah.
I won't require you to say a whole lot, and I'll try to run through this for you. Mr. Hart, if you will, raise your right hand. I'm gonna place you under oath. Mr. Hart, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth? So help you God. Is that true?
Sorry.
All right, thank you. You can put your hand out. All right, Mr. Hart, are you a United States citizen who reads, writes, and speaks English?
Yes.
Have you ever been diagnosed with a mental condition?
Yeah.
What have you been diagnosed with?
Paranoid schizophrenia and bipolar and anxiety.
Okay. Are you currently undergoing treatment or on medication for those?
Yes, sir.
Okay. And do you feel like you have a rational understanding of what's going on in this case here today, despite your mental condition?
Yes, sir.
Okay. And your attorney is Mr. Ashmore. Are you pleased with him as your attorney?
Yes.
Do you feel like you've had enough time to talk with him about your case and have all your legal questions answered?
Yes.
Is there anything about the paperwork that you've read and signed today that you do not understand?
No, sir.
Okay. And Mr. Ashmore, do you believe that Mr. Hart is competent to enter into this plea today? Have you explained to him his rights as they pertain to this case? And do you believe that he is intentionally, knowingly, voluntarily entering into this plea and waiving his rights herein?
Yes, Judge.
All right. Thank you, Mr. Ashmore. All right, Mr. Hart, you are charged by indictment with a second-degree felony offense of burglary of a habitation, which has a range of punishment of not less than 2 years in prison or more than 20 years in prison. That's the range of punishment, and a fine not to exceed $10,000 if imposed. I see the plea agreement in your case, Mr. Hart, that you've reached with the state is that you would plead guilty to burglary of a habitation. The state would be recommending to the court that your punishment be assessed at 13 years confinement in prison. You would pay a $2,500 fine, $200 restitution, and the state would also dismiss as part of the plea a criminal trespass. And you would also receive 336 days credit towards your sentence for the time that you have been in jail on this cause. Is that your understanding, Mr. Hart?
Sir.
Okay, so Mr. Hart, at this time, I've explained the range of punishment. I've explained the plea agreement, and this is what you're asking to go forward with today. Is that correct?
Yes, sir.
Okay, Mr. Hart, then how do you plead to burglary of a habitation?
Guilty.
Do you plead guilty to that crime because you are guilty of committing that crime and for no other reason?
No.
Are you pleading guilty because you are guilty of committing that? You're not pleading guilty just because that you want to take a plea deal and move your case. Is that correct? You're pleading guilty because you are guilty of committing burglary of a habitation?
Yes, sir.
Okay. All right, court will accept the defendant's plea of guilt. Mr. Ashmore, any objection to the evidence supporting the plea?
No, Judge.
All right, court accepts the defendant's plea of guilt. Court will also take judicial notice of the defendant's judicial confession, and the court admits State's Exhibit 1. Anything further from the state?
Your Honor, the state is in compliance with victim notification. We do not have anything to present to the court on that at this time. But if you will note, the judgment does include restitution of $200 to the victim for damage to her property during the burglary.
Okay, great. Thank you, Ms. Heisel. Anything further from the defense, Mr. Ashmore?
No, Judge.
All right, the court's going to review the evidence briefly. All right, the court has reviewed the evidence. I do find sufficient evidence to convict Mr. Hart of this offense. The court will follow the plea agreement in this case. Court convicts Jamie Floyd Hart of burglary of a habitation, a second-degree felony. Ms. Heisel, I assume that the court, that the state is abandoning the enhancement paragraph alleged in the indictment.
Yes, Your Honor.
All right, court finds that the state has abandoned the enhancement paragraph, that this is a true second-degree felony. Court assesses his punishment at 13 years confinement in the Texas Department of Criminal Justice Institutional Division, orders him to pay a $2,500 fine, $200 restitution, $290 court costs, $85 reimbursement fees, and the court dismisses a criminal trespass under section 1245 of the Texas Penal Code. The court awards Mr. Hart 336 days credit towards his sentence for the time that he has spent in jail on this cause. Mr. Hart, you're hereby remanded to the custody of the sheriff so he can carry out the terms and conditions of the sentence. I'm going to have you step over with Deputy Everett to be fingerprinted. Good luck to you, sir. Thank you for being here, Mr. Ashmore. Hope you get to feeling better.
Thank you. I've got one more, Your Honor.
You do? Okay.
Ms. Lee.
Susan Lee, CR 22151. And what are we doing?
Judge, I'm just gonna motor through this. We have reviewed the indictment. It's a state jail felony. We've discussed the punishment range. She's aware of the allegations in the indictment. Her name is spelled correctly both places. We're asking the court to waive formal reading, allow us to enter a plea of not guilty, and further negotiate with the state. We do have all of the paper discovery. I need to pick up video discovery today. And we'll be back at the court's next available, hopefully with a resolution.
All right, court will find that Ms. Lee has waived the formal requirements of arraignment. The court will enter her plea of not guilty into the record. We will set the matter for pretrial. Mr. Ashmore, I've been setting things on February 7th and or 9th. If you need that much time, I also have one setting next week, or I can get you in on January 24th. If we need sooner. Mr. Schmidt, while Mr. Ashmore is looking, Judge Winters was gracious enough to sign an order assigning Mr. Dixon's case to the 294. So we'll resume that plea in just a moment.
Great, thanks. Judge, for the moment, let's go 2-7. I think I'm going to have some special settings in January that look like they will go now.
Okay, court sets Ms. Lee then for pretrial on February 7th. And that'll be at 1:30.
Thank you, Judge.
You're welcome, sir.
May I be excused, Your Honor?
Yes, thank you, Mr. Ashman. Hope you get to feeling better. Mr. Schmidt, do you want to resume with Mr. Dixon?
Yes, sir. I'm ready on month and this.
Yeah, go ahead and bring Mr. Dixon back in. All right, we are back on the record in CR 22269 and 2022382, State versus David Paul Dixon. Court will note for the record that the county court at law has transferred and the 294th has accepted the misdemeanor case in 2022-382. All right, and let's see, have I sworn Mr. Dixon in yet? I don't think that I have I?
Yeah, Judge.
Okay, Mr. Dixon, if you'll raise your right hand, sir, I'm going to place you under oath. Sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth? So help you God.
Yeah, say copy.
Okay, yeah, just say, yeah, you say yes?
Yes.
Great, thank you. You lower your hand. Sometimes there's a delay. Just make sure you speak up loudly and clearly for me. Your name is David Paul Dixon, is that correct?
Yes.
And Mr. Dixon, are you a United States citizen who reads, writes, and speaks English?
Yes.
Have you ever been diagnosed with a mental condition?
No, sir.
In this case, you're represented by your attorney, Mr. Richard Schmidt. Are you pleased with his representation?
Yes, sir.
Do you feel like you've had enough time to talk to him about both of your cases to the point that you've had all your legal questions answered?
I have.
Is there anything about the paperwork that you've read over and signed today that you do not understand?
No, sir.
All right, Mr. Schmidt, do you believe that Mr. Dixon is competent to enter into the plea agreement, that he understands the waivers of rights that he would be making in the plea agreement, and that he understands the advantages and disadvantages of a deferred adjudication plea?
Yes, sir.
All right, Mr. Dixon, you are charged by indictment with a state jail felony offense of burglary of a building that carries a range of punishment of not less than 6 months in prison or more than 2 years in prison if you were convicted and sentenced. And on the misdemeanor charge of assault, that is a Class A misdemeanor and carries a potential range of punishment up to a maximum 365 days or 1 year in the county jail, and a fine, if imposed, of not more than $4,000. You've heard Mr. Schmidt tell me, the court, what the plea agreement is, that you would plead guilty to both crimes in exchange for the state's recommendation that you be placed on deferred adjudication. Is that correct?
Sir.
And you understand that if the court places you on deferred adjudication, community supervision, that if you violate any of the terms and conditions of your community supervision, the court could could conduct a hearing, could hear the evidence, and if the court finds you violated, the court could convict you of either or both offenses and could revoke you on either or both offenses and sentence you to either prison up to the maximum 2 years for the felony and up to a maximum 1 year for the misdemeanor. You understand all of that?
Yes, sir.
And you still wish to go forward?
Yes, sir.
All right, Mr. Dixon, then how do you plead to burglary of a building?
Guilty.
How do you plead to assault, Class A misdemeanor? And are you pleading guilty to each one of those crimes because you are guilty of committing each one of those crimes?
Yes, sir.
Has anyone threatened, forced, or pressured you to plead guilty to either crime today?
No, sir.
All right, the court does accept the defendant's plea of guilt. Mr. Schmidt, any objection to the evidence supporting each plea?
No objection.
All right, the state or the court admits the state's evidence in each case respectively. The state's exhibit 1, and the court does take judicial notice of Mr. Dixon's judicial confession. Anything further from the state?
No, Your Honor.
Do we have victim compliance on the assault and burglary of a building?
I should have anticipated you were going to ask me that. I do not. Let me check, Your Honor. That was obviously one of the county court of law prosecutors. Let me check.
Okay. While we're checking on that, Mr. Schmidt, anything further from the defense?
Yes, Judge, I'd like to call Mr. Dixon briefly.
Yes, sir. Go ahead.
Mr. Dixon, I heard all your answers to the judge's questions about your understanding of your plea and our conversations pertaining to your representation, right? And I want to make sure that you understand that you do not have to enter a plea, and we could take all of these cases to trial if you wanted to. Understand that? Yeah. And do you believe that I have explained to you the legal meanings of the charges as well as the consequences of those definitions?
Yes, sir.
And do you have, and I've also told you that once we're done here today, that you will not be able to undo it, correct?
Yes, sir.
So you understand that there are no appeals, and you feel confident that I have represented you to the point where you know what you're doing and you wish.
Yes, sir.
Okay, I'll pass the witness.
Thank you, Mr. Schmidt.
State has no questions for this witness. Judge, state is in compliance with victim notification. Appears as though a victim impact statement was provided to the victim, but we have not received anything back in regards to that.
Okay, thank you, Mr. Woodwhite. And Mr. Woodwhite, can you go ahead and give me the evidence to support each of the pleas?
Yes, Judge. In cause number CR 22-00269, the state jail felony, Canton Police Department responds to burglaries at a strip mall involving Cricket Wireless, Sears, and the Home Store Rent to Own. CPD investigates and watches a closed circuit television and sees a Lincoln Navigator pulling around the stores at night on the night in question and sees the defendant walking around. He is identified both by his appearance and the fact that he has a cast on his arm. Canton puts out a social media their information, and later that night, DPS responds to a crash with the Lincoln Navigator with the defendant with a broken arm. Defendant's mom also contacts Canton and says that the defendant wrecked her vehicle, and that there's some property that was removed from one of the stores in the vehicle. They get a warrant, interview the defendant, who confesses basically only to the Cricket Wireless, claims that he broke his arm and his friend gave him what he believes to be marijuana, but he doesn't remember much of the night, but does remember looking around the buildings for trash he could recycle, and vaguely remembers breaking into Cricket Wireless. And so that's the case that we're proceeding on. On that case, and let me pull up the misdemeanor.
And that's 2022-382, the misdemeanor.
That is CR 22-269, burglary of a building, is breaking into Cricket Wireless.
Yeah, I know. I'm telling you that the misdemeanor cause number for you to look it up is 2022-382.
Okay, I thought you were asking if that summary was for the assault. I'm sorry, Judge.
No, it's okay.
In 22-00382, Van Police Department is called out for a disturbance in progress. The defendant, they respond, and the subject, who's the defendant, is on top of a silver Kia, breaking the windshield out. Mr. Davidson has blood on his hands, arms, and chest. Upon further investigation, Mr. Dixon had thrown something which hit the victim, Miss Reed. She had minor injury. I'm sorry, Judge, I'm trying to summarize real fast while reading. When interviewed, Mr. Dixon admits to throwing a cell phone that he believes struck the victim, Miss Reed, in the forehead. So that's the assault.
Thank you, Mr.
I'm sure the report is much more in depth than that. I'm just trying to summarize very quickly. Obviously, this is not my case originally.
Sure. Any objections or additions, Mr. Schmidt?
No, sir.
All right, then based on the evidence as presented, the court finds that there is sufficient evidence to convict Mr. Dixon of each offense. The court will follow the plea agreement reached between the state and the defense. Court hereby defers the finding of guilt in CR 22-269 on the charge of burglary of a building. Court places Mr. Dixon on 2 years community supervision, orders him to pay a $1,000 fine, $290 court costs, and $535 reimbursement fees. The court in 2022-382 to the misdemeanor A charge of assault finds that there is sufficient evidence to convict Mr. Dixon. The court will defer a finding of guilt based on the plea agreement. Also places him on 2 years community supervision to run concurrent with the other community supervision at CR 22-269. Court orders him to pay $270 court cost and $30 reimbursement fees in that case. Mr. Dixon, you're hereby remanded to the custody of the Community Supervision and Corrections Department so they can carry out the terms and conditions of the sentence. I'm going to have you step over with Deputy Everett to be fingerprinted. Then the probation officers will tell you about the next step.
Thank you.
You ready on Brian?
Monk. Yes, sir.
All right, Mr. Monk. All right. Mr. Monk, you were out on work duty, weren't you?
Sir,
So did we save you? Were you having to do back-breaking work or did we drag you back to court?
I'm doing work, but it's okay.
Okay. All right, this is cause number CR 22403, State versus Brian Allen Monk. We're set for plea today. I thought you might want to come back and resolve your case today. That's why I pulled you off work duty. So, Mr. Schmidt, I don't think I have the terms of the plea. Fill me in, sir.
Yes, sir. Upon a plea of guilty, the state's recommending that Mr. Monk's punishment be assessed at 11 months state jail, $1,000 fine, 180 restitution to DPS laboratory, and they're agreeing to take under consideration DA 2022-1297, which is a possession case. And he had 290 court costs, $15 reimbursement fees, and 60 days credit time towards that sentence. In addition, Judge, we are waiving indictment and pleading to an information, and we have executed the waiver of grand jury presentation.
Great, thank you for that, Mr. Schmidt. All right, Mr. Monk, if you'll raise your right hand, I'm going to place you under oath. Mr. Monk, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
All right, thank you, sir. If you can lower your hand, you'll just make sure you speak up loudly and clearly so that I can hear you and so that my court reporter can take down what's being said. And Mr. Schmidt, is my audio okay over there? I may be having some problems with my microphone. Can you hear me okay?
I can hear you fine, Judge.
Okay, good. All right. Mr. Monk, you heard the plea agreement that Mr. Schmidt has stated to the court. Is that your understanding of the plea agreement, what you're asking the court to approve today?
Yes, sir.
Mr. Monk, are you a United States citizen who reads, writes, and speaks English?
Yes, sir.
And have you ever been diagnosed with a mental condition?
No, sir.
Are you pleased with Mr. Schmidt as your attorney?
Yes, sir.
Have you had enough time to talk with him about your case and had all of your legal questions answered?
Yes, sir.
The paperwork that you've read over and signed today, do you have any questions about that? Anything you don't understand?
No, sir.
And where you signed, that's your true and correct signature, and you only signed once you understood what you were signing, correct?
Yes, sir, Judge.
All right, Mr. Monk, the range of punishment for a state jail felony offense of possession of a controlled substance in penalty group 1, less than 1 gram, is, if convicted, is not less than 6 months in state jail prison and not more than 2 years in state jail prison, and an optional fine not to exceed $10,000. Do you understand that full range of punishment?
Yes, sir.
The court, in reviewing the plea agreement, finds that it legally fits within the range of punishment. Now, Mr. Schmidt has indicated to me that you have agreed to allow the state to prosecute you without having your case presented to the grand jury. Do you understand how the grand jury process works and what you're giving up today?
Yes, sir.
And you understand that once you waive your right to a grand jury, it can't be restored to you?
Yes, sir, I understand.
And has anyone threatened you, forced you, pressured you to make you feel like you had to waive your right to a grand jury?
No, sir.
All right, court will approve the waiver of the case being presented to the grand jury. Court will authorize the prosecution of Mr. Monk by the state on information. Mr. Monk, how do you plead to that crime?
Guilty.
Are you pleading guilty because you are guilty of committing that crime and for no other reason?
Yes, sir.
Has anyone threatened you, forced you, pressured you to plead guilty today?
No, sir.
All right, court accepts the defendant's plea of guilt. Mr. Schmidt, any objection to state's evidence?
No objection, Judge.
State's evidence is admitted and the court takes judicial notice of the defendant's judicial confession. Anything further from the state?
No, Your Honor, we had rest and close.
From the defense?
Nothing further, Judge.
All right, if you can give me the evidence to support the plea, Mr. Woodwhite.
Yes, Your Honor, on the date in question, which is November 6th of last year, officer with Grand Saline Police Department was dispatched to a person who had fallen asleep at the wheel on a roadway. Upon arrival, the defendant is asleep over the steering wheel with the vehicle running. The officer is able to open the door and turn the car off at which time the defendant begins to awaken. While speaking to the defendant, the officer sees a glass meth pipe on the driver floorboard. The defendant is taken into custody at that time. Upon search of his person, they located a small canister with 0.54 grams of methamphetamine inside. They also search the vehicle and find a liquid THC vape pen, which is the possession case that is being taken into consideration, Your Honor.
Thank you, Mr. Clark. Anything further, Mr. Schmidt?
No, Judge.
Okay, all right, then based on the evidence as presented, the court finds that there is sufficient evidence to convict Mr. Monk of this offense. The court will follow the plea agreement reached between the state and the defense. The court hereby convicts Brian Allen Monk of possession of a controlled substance, penalty group 1, less than 1 gram. Court assesses his sentence at 11 months confinement in state jail. Court orders him to pay a $1,000 fine, $180 restitution, $290 court cost, $15 in reimbursement fees. The court dismisses DA 2022-197, and the court awards Mr. Monk 60 days credit towards his sentence for the time that he has spent in jail on this cause. Mr. Monk, you're hereby remanded to the custody of the sheriff so he can carry out the terms and conditions of the sentence. We'll have you step over with Deputy Everett to take your fingerprint. Good luck to you, sir.
Thank you, Judge. I believe that's all I have, Judge.
Thank you, Mr. Schmidt. Appreciate you, sir.
You have a good day.
All right, so I show that we still have Josie Bohannon. Is Miss Bohannon in the courtroom? I don't need her up. I just need to know if she's in there.
He is not.
She is not? Okay. I think that she's the only one that I have left on the docket. So go ahead and have her brought up. But Ms. Heisel, Mr. Woodwike, I'm going to invite you to a breakout room. Going to have a talk with you about Miss Bohannon. We have a slight issue.
Mr. Adams already texted us, Judge. I believe we're read in.
Okay, so what I would be, I don't know what your position is. It looks like well, let's go ahead and get Miss Bohannon in here, and that way we'll have this conversation with her. And I'll tell you what I'm thinking. And
They're bringing him up.
okay, thanks. Steve, do you know what the status and Karen, if you're over there, you may be able to help me. Do we know what TDCJ is doing on sentences that are considered served in county before they get to TDC? Are they releasing from the sheriff's office? Or are they still being processed? Are they having to be transported and processed out from TDC?
My understanding, Judge, and this may be a little out of date, again, this was probably prior to even the pandemic, is that if a person had been down previously, they would parole them in absentia or consider them served. If they've already been processed previously in TDC, they would just release people, but if they hadn't, then they would have to go down. So a lot of it depends on the offender, whether they've already been processed in TDC or not.
That to get them a TDCJ number?
To get them a TDCJ number, get them photographed, get official TDCJ fingerprints, all that kind of stuff is my understanding. But that may be out of date. I don't know what their current policies are.
Assuming that's the case, can you lay eyes on the criminal history to see what category she may fit in, assuming that that's still following those procedures?
Are we talking about Ms. Bohannon?
Correct. Deputy Everett,
Yes, sir.
can you ask someone from the jail administration who may be able to answer this question for us? Will you see if there's anyone there who can tell us if someone were to have credit for all of their sentence, but it be a TDC sentence, are they still requiring them to go down and process out? Could you find somebody like that?
Yes.
Thanks, sir.
Judge, based on my our criminal history of the defendant from a year and a half ago, it does not appear as though she's ever been to TDCJ, either state jail or the penitentiary division.
Okay.
I got you an answer. Like it.
Okay, I'm ready.
Sometimes they do and sometimes they don't.
No, you turn around and you go back in there and you get a better answer.
They said it all depends on what TDC wants to do that day.
That's a very lawyer answer of them.
Yeah, that's probably they were advised by their general counsel to answer in such a way. Okay. Well, what I was wondering for Miss Bohannon was, oh, is she in here? Oh, hi, Miss Bohannon. I didn't know you were over there.
Hello, how are you?
Good. Okay, we're gonna go ahead and we're gonna be off the record for a moment. We're just gonna have a discussion amongst ourselves, okay? So I don't know if anyone's told you, but Mr. Adams is ill today and couldn't even be here by Zoom. He could be here next week, Tuesday is my next setting. I'm looking at your plea agreement and I saw that you were getting a 6-month sentence in TDC. You were getting full credit for the 6 months that you've been in jail. And so I was trying to figure out whether or not to keep you in custody until Tuesday, to let you out today, have you come back on Tuesday, trying to figure out whether you go to prison to get to get a number process, basically booked in, booked out at the facility so they can put you in their system with your identifiers and things of that nature. We've been trying to figure that issue out. I was thinking that if you did not have to go down to TDC, then what I would do today is just give you a PR bond and then order you to come back on Tuesday to do your plea with Mr. Adams. And so that's kind of what I'm trying to figure out right now. But what we've learned is that we're not sure if you're going to have to be transported or not. If you're going to have to be transported, I would just keep you in custody, right? If you weren't going to be transported, I was going to let you out on a bond today and a PR bond where you don't have to post anything. It's going to allow the state to weigh in on that. But I'm not sure we have a definitive answer. What do you think, Miss Bohannon? What do you think?
Your Honor, I also have a hold in another county for me as well, and I'm not sure if they're running it concurrent with my time or not, so either way, I'll still be in custody.
Okay, Miss Bohannon, that's the most helpful piece of information you could have given me.
She is more helpful than the state in this regard, Judge. I apologize for that.
Okay, all right. Well, I want you to know I was really struggling on, man, how do I make sure that you're not being held any longer than you need to be? So that does free me up to not have that concern if you do have another hold. So Mr. Adams, we have contacted him, and he did say that he could be here on Tuesday. So what we'll do is we'll just reset you for Tuesday, and it'll be a little bit of a delay, but not much. Okay.
Okay, thank you.
All right. Do you have any other issues or questions?
No, Your Honor.
All right. Thank you, Ms. Bohannon. I do appreciate your help.
And that's January 10th, Your Honor.
January 10th. Yes. Next Tuesday at 1:30 is when we'll see you back. Okay.
Okay.
And here, I'll tell you what, Miss Deputy Everett, can you give her a reset notice just so she'll have that in her records? It's CR 22-2. Just so that she has something. And Ms. Bohannon, what other county has a hold on you?
Smith County.
Smith and Tyler. Okay.
Yes,
Is
sir.
it-
I should be time served there as well, but I think I just have to go before the judge over there as well.
Okay. Is it a probation case or a non-probation case?
Yes, sir. It's a probation case.
Probation. Yeah, you're probably right about that then.
Yes, sir.
CR 22-2, and we'll just reset for plea, Brian, on 1/10 at 1:30. All right, thank you, Ms. Bohannon. We'll see you next week.
Yes, sir.
All right, Brian, I think that's everything. We're gonna call Mr. McKibben's name. Did I heard Deputy Woosley calling the name? Did he give you a response at all?
Yes, no response.
No response. Okay. All right. Let the record reflect cause number CR 22-222, State versus Travis Glenn McKibben. Mr. McKibben is represented by Mr. Manning. Mr. McKibben was ordered to appear at the jail today to enter his plea and go into custody. Mr. Manning has indicated to the court that he's had communication with his client, and his client indicated that he was not able to be here at the time ordered, but he'd be trying to make his way to the Van Zandt County Justice Center. So the court is going to, the court has had his name called loudly, distinctly 3 times at the Justice Center and at the Van Zandt County Courthouse. There's been no response. So the court hereby issues a judgment nisi and alias capias, and will issue a warrant for Mr. McKibben's arrest. If Mr. McKibben appears at the Van Zandt County Justice Center, Deputy Everett, will you leave a note with the staff there that we will work feverishly to get the warrant activated so that they can just take him into custody?
Will do.
All right. And I think Miss Abney is still on with us. I don't know if she
is, Your Honor.
She is. Okay. Miss Stephanie, if you wouldn't mind, if we can do that nice ASAP for Travis Glenn McKibben, CR 22-222. And if you'll just email that over to Patty, I'll get that printed, signed, and to the clerks. With that, we will be adjourned for the day and back in court on criminal cases next week.
Thank you, Your Honor.
Thank you, sir. Appreciate you. Hope you get feeling better, Mr. Woodwhite.